Hello, good evening, everybody. This is Outside the Matchbox, episode 11, and this is an evening episode. And today we're going to be uh, going over the Department of Justice's reply to Donald's partial appeal to the Supreme Court. As I have done with previous filings, I am going to go through excerpts that I find will inform y'all. Now, before I do that, I will let you know that at any point you may see a big dog come behind me. He's currently sleeping, so I'm going to let sleeping dogs lie. And if you haven't subscribed yet, please subscribe and like and share. Uh, so now let's get on with it. So the appeal starts, the DOJ's response starts with, this application concerns an unprecedented order by the district court restricting the executive branch's use of its own highly classified records in an ongoing criminal investigation and directing the dissemination of those records outside the executive branch to a special master review. At the outset, the DOJ lays out the very basic judicial overreach and abuse of discretion that uh, Judge Cannon irresponsibly exercised by even granting the motion of special master, uh, because and then restricting the executive branch's uh, ability to access its own records for an ongoing investigation. District courts have no general equitable authority to superintend federal criminal investigations. Instead, challenges to the government's use of the evidence recovered in a search are ordinarily resolved through criminal motions practice if and when charges are filed. And this is a reminder that the DOJ has pointed out several times that no charges have been filed. We are actually on a tangent from Judge Reinhardt's uh, investigation, the DOJ's investigation that's being supervised by Judge Magistrate Bruce Reinhardt. And Judge Cannon intervened in that and granted a special master review on the basis of equitable jurisdiction. And that issue the DOJ has brought up in its full appeal to the 11th Circuit, which the 11th Circuit has expedited. And we will learn, and we will and this brief also tells the Supreme Court that there is now a schedule for the 11th Circuit to decide this whole matter, and that it is standard practice for the Supreme Court to give the Circuit Court of Appeals great deference in such matters. And the matters is the very substance of the matter is Donald Trump asserting that the 11th Circuit didn't have pendant appellate jurisdiction, meaning the power to hear an interlocutory appeal, meaning the power to hear an appeal that is part of an ongoing process, court case, and to what extent an appellate court has appellate jurisdiction. Because as a general matter, the appellate court has limited jurisdiction, and so does the Supreme Court. So Well, actually, the Supreme Court can do whatever the fuck it wants. But anyway, uh, okay. Next, the Court of Appeals granted that modest relief of the DOJ asking for a partial stay on the 100 documents with the classified markings, saying that the United States is substantially likely to succeed in showing that the district court abused its discretion in exercising jurisdiction over applicant's motion as it concerns the classified documents, and that all of the equitable factors favored a partial stay. So this is DOJ informing the Supreme Court of the 11th Circuit's order. Most notably, applicant, meaning Donald Trump, has not even attempted to explain how he is irreparably injured by the Court of Appeals partial stay, which simply prevents disclosure of the documents bearing classified markings in the special master review during the pendency of the government's expedited appeal. So, in a masterful sentence, the DOJ here points out that there's at no point has Donald Trump shown that he's irreparably injured by the partial stay that the 11th Circuit has granted as it pertains to those 100 classified documents. And also points out that there's an expedited appeal that's in process. Indeed, applicant does not challenge the Court of Appeals determinations that applicant will suffer no meaningful harm from a limited stay. That the government would have been irreparably injured absent the stay, and the public interest favors a stay. So he has not challenged any of those claims. The only thing he's going up to the Supreme Court for is to force the DOJ to return those highly classified documents to Judge Deary, the special master, and Donald's lawyers. I would like to emphasize and Donald's lawyers because that's pretty much what he actually wants. He wants to know the direction in which the DOJ is going and what exactly the DOJ is looking at, and also to delay and obstruct. As the court explained, allowing the records would irreparably injure the government because, for reasons too obvious to call for enlarged discussion, the protection of classified information must be committed to the broad discretion of the agency responsible. And this must include broad discretion to determine who may have access to it. The agency responsible being NARA, the National Archives, under the PRA, which is the Presidential Records Act. And because those are in violation, NARA contacted DOJ. DOJ coordinated with Donald's attorneys, and this appeal extensively talks about that factual record and describes it in great detail about how this is not out of nowhere. This is a lawful search warrant issued by a judge magistrate, as I have said ad nauseum from the very beginning. And so then we go on to, instead, applicant principally asserts that although the Court of Appeals had jurisdiction to stay the district court's injunction, it lacked jurisdiction to stay special master's review. So essentially, there's the DOJ saying that he's flip-flopping all of his arguments. There's no substance in his arguments. The Court of Appeals has jurisdiction over the injunction, but not over the 11th, over the special master review. It's absurd. First, the Court of Appeals correctly held. Now, this is the DOJ saying. First, the Court of Appeals correctly held that it had pendent jurisdiction to address the special master's review because the injunction, which precluded the government's use of the documents pending resolution of the special master's review, it is inextricably intertwined with that review. Second, USC 28 USC 1292A1 grants appellate jurisdiction to review interlocutory orders of the district courts granting, continuing, modifying, refusing, or dissolving injunctions. Appellate jurisdiction thus lies over the entire order granting an injunction, as this court has held in interpreting other statutes granting jurisdiction to review particular types of orders. So this particular appeal is a jurisdictional procedural appeal. It's not frivolous because of the matter of jurisdiction is actually in question from the very beginning. Excuse me, water break. And also because categorically, while Donald has just asserted that somebody like Judge Cannon would have jurisdiction over a DOJ investigation over which a judge magistrate is overseeing, he just goes and flips and says, other people don't have jurisdiction where they rightfully do, but I can claim jurisdiction wherever. Therefore, I will just skip over the 11th Circuit and be incredibly disrespectful to the 11th Circuit and take a partial appeal to the Supreme Court while there are pending motions to expedite at that time the appeal in the 11th Circuit, which subsequently the 11th Circuit granted. And now the 11th Circuit appeal is in expedited. I think we should hear at least the arguments being presented before Thanksgiving. Third, a directive compelling the executive branch to disclose information that is classified or otherwise implicates national security is itself immediately appealable as a collateral order. This is an argument that the DOJ is asserting based on Mohawk Industries versus Carpenter, which is a Supreme Court precedent. Applicants certainly cannot establish the clear error required to justify the relief he seeks, particularly because he does not acknowledge, much less attempt to rebut, the Court of Appeals' conclusion that the district court's order was a serious and unwarranted intrusion on the executive branch's authority to control the use and distribution of extraordinarily sensitive government records. So Donald has made no showing, no attempt to, he has made none of the required, presenting of proofs that's needed for there to be an argument or a dispute that Judge Cannon claims there is. While claiming this is not a merits case, merits of the investigation, we're looking at what's privileged and what's not, and then it's going over to saying, no, this is not. It's confusing, it's confounding, if the Supreme Court does not slam this down and kick the entire thing out just because they don't want to be overt, they are every day that this goes on is weakening the legitimacy of the judiciary. It's been going on for 2 months, over 2 months now, and I don't know. It's annoying to say the least. The DOJ goes on to say the PRA provides that the United States retains complete ownership, possession, and control of presidential records, which the law defines to include all records created or received by the president or his staff in the course of conducting activities which relate to or have an effect upon the president's official duties. And this is important for a couple of reasons. The PRA specifies that when a president leaves office, NARA shall assume responsibility for the custody, control, and preservation of and access to the presidential records of that president. And he did not return those documents. He did not follow that process. He, in fact, kept that information, and he lied about it more than once and made Christina Bobb lie about it in a sworn certification. So, and at no point of this whole investigative process of the 11 months has Donald Trump asserted any sort of privilege or immunity or shown any proof of privilege or immunity. So, appellant did not assert any claim of privilege. Applicant's custodian provided sworn certification that written documents after a diligent search had all been returned in that particular package that Christina Bobb handed over. And after that, when the DOJ discovered that there was more classified documents, the judge magistrate found probable cause that evidence of those crimes would be found at Mar-a-Lago and authorized the government to seize, among other things, any physical documents with classification markings, along with containers, boxes in which such documents are located. Warrant and attachment. The magistrate also approved the government's proposed filter protocols for handling any materials potentially subject to personal attorney-client privilege. Excuse me. This is the DOJ telling the Supreme Court, look, a judge magistrate has signed off on this based on probable cause and has approved the filter protocols, which, by the way, were complete before the special master review even began. The government executed the warrant, found 11,000 documents. Roughly 11 bore classified markings with extremely restricted markings, and in some instances, so restricted that FBI counterintelligence personnel required additional clearance to review the documents. Now, we remember that from previous filings. So, and then the DOJ says the court referred generally to the fact. So now the DOJ is saying, but despite all of that, that district court, Judge Cannon, says that there are factual and legal disputes as to precisely which matters constitute personal property or privileged materials. Well, that is answered in the warrant and the judge's approved filter protocols. That's what those were meant to take care of. The warrant has to be specified. We've gone over this many times, as has the DOJ, as is the 11th Circuit, but Donald and Judge Cannon simply don't get it. The question is, will Clarence Thomas? And the court, the district court, reiterated that the injunction preventing the government from using the seized records for investigative purposes was necessary to uphold the value of the special master review. So the value of the special master review is a waste of money and time and delays because it is accomplishing effectively nothing other than to obstruct and delay an ongoing criminal investigation. The Court of Appeals noted that the injunction expressly applied to pending completion of special master's review and in natural conjunction with the appointment of the special master. And the court explained that the pendent jurisdiction would allow it to review even an otherwise non-appealable order, whereas here it is inextricably intertwined with an appealable decision. So here we're going back to the jurisdictional issue. The court concluded that the government is substantially likely to succeed in showing that the district court abuses discretion in exercising jurisdiction over appellant's motion as it concerns the classified documents. Among other things, the Court of Appeals emphasized the district court's conclusion that the government did not engage in any sort of callous disregard for constitutional rights that circuit precedent makes an indispensable prerequisite for an exercise of equitable jurisdiction in this context. So it is saying that our circuit is held that in order for you to, the 11th Circuit is held, or the circuit precedent of the various circuits have held that absent showing of callous disregard of constitutional rights, you cannot exercise equitable jurisdiction. Donald Trump did not dispute that conclusion. Indeed, his filing in the Court of Appeals did not even allege the search violated the Fourth Amendment. I don't recall ever reading him going much into the Fourth Amendment violation because, that's a substantive violation that you do in a court of law. And no lawyer in their right mind would bring that up now. The Court of Appeals also found that the government would suffer irreparable injury absent a stay, crediting an affidavit from a senior FBI official. The court concluded that an injunction delaying or perhaps preventing this United States criminal investigation from using classified material risks imposing real and significant harm on the United States and the public, including risks to national security. The court also concluded that allowing the special master and the appellant's counsel to examine the classified records would needlessly jeopardize the long recognized compelling interest in protecting the secrecy of information important to our national security. So their compelling interest is the highest form of scrutiny. So here the DOJ is saying that the 11th Circuit is looking at this case with the highest level of scrutiny in favor of the government, because the government has a compelling interest in protecting the secrecy of information important to our national security, not a private citizen at his country club in his desk. The court further held that appellant had not shown that he would suffer substantial injury from a limited stay applicable only to the records bearing classification markings, and that the public interest favored a partial stay pending appeal. So Donald hasn't proved that he's had any sort of injury. He hasn't proved that he has declassified. He hasn't proved that the documents he claims are personal, and he wants them back outright. He wants some of a fourth branch of government now to work on his behalf. Fortunately, Judge Deary is not working on his behalf, but because Judge Cannon is micromanaging, this was expedited by the 11th Circuit. And now we have Donald retaliating against that with this frivolous appeal. The issue at hand may be semi not frivolous, but the abuse of process and the flagrant disrespect of the judiciary and the way that the judiciary works, if the Supreme Court doesn't act, only goes to weaken the judiciary in the long run. Because in a way, Donald is operating as a shadow Article 2 presidency power-ish force, telling both the Article 3 judiciary what to do and taking appeal wherever he wants to take it, but also demanding of the incumbent Article 2 presidency to bend to his will. It's despotic and dictatorial, you know? Meanwhile, before the district court denied a stay, it had issued a September 15th order appointing Judge Deary as special master and providing the promised details and mechanics of the review process. After the Court of Appeals entered a stay, the district court sua sponte modified the September 15th order by deleting portions of that order addressing review of the records bearing classification markings. So it's talking about how Judge Cannon is really just going all over the place. After the Court of Appeals granted the stay, it also granted the government's motion to expedite the appeal, which applicant had opposed. Briefing is set to be complete by November 17, 2022. Meanwhile, the government's investigation is ongoing, as is a national security review and assessment being coordinated by the Office of the Director of National Intelligence. This is the DOJ essentially giving the Supreme Court an update on how the process is going. So now we go to the substantive argument of the Justice Department. Excuse me, water break. The application should be denied. A stay granted by a court of appeals is entitled to great deference from this court. Garcia Mir versus Smith, 1985 Rehnquist Court opinion. Important because Rehnquist was a conservative Republican Chief Justice. Vacatur of such a stay is appropriate only when the case is very likely to be reviewed by this court upon final disposition in the Court of Appeals. The Court of Appeals, number two, the Court of Appeals is demonstrably wrong in its application of accepted standards in deciding to issue the stay. And three, applicants' rights may be seriously and irreparably injured by the stay. This is 2020 Supreme Court opinion. Indeed, the application does not even address the Court of Appeals reasoning supporting its conclusion that the government is substantially likely to succeed on the merits. Instead, applicant focuses almost entirely on the assertion that the 11th Circuit lacked jurisdiction to stay the special master's review. This is footnote 2. The analysis would be different if the Court of Appeals were to affirm the district court's unprecedented order, enjoining the government pre-indictment for using classified records recovered under a lawful search warrant pending a special master's review is an extraordinary intrusion raising significant national security concerns. This is Department of Navy versus Egan, 1988 Supreme Court precedent. That is especially so because those records are the very subject of the investigation concerning wrongful retention of documents and information relating to the national defense, as well as obstruction of justice. So uh, here the DOJ pretty much outlines what is happening here, what the district court has done, on what basis of equitable jurisdiction that does not exist in this case, and neither does Donald show that there's this substantial harm and injury. Instead, Donald argues only that the Court of Appeals lacked jurisdiction to stay the September 5th order to the extent it requires the government to submit the classified documents to the special master review. So talking about how arbitrarily minuscule this argument and appeal is. Pendent appellate jurisdiction permits review of an otherwise non-appealable issue if it is inextricably intertwined with or necessary to ensure meaningful review of an immediately appealable ruling. In staying the injunction, the Court of Appeals concluded that the district court likely abused its discretion in even entertaining applicants' motion as to the records bearing classification markings, a conclusion that necessarily dictates that the special master review of those records is improper. The government has also argued that the injunction is unwarranted precisely because the special master review process is unnecessary with respect to the documents bearing classification markings, over which applicant has no plausible claim of privilege or return. So, because they are classified, this court, meaning the Supreme Court, made exactly that point in construing parallel language. No. Okay. Now, it is thus the entire order that is appealable under Section 1292A1. This court made exactly that point in construing the parallel language of Section 1292B. As the text of 1292B indicates, appellate jurisdiction applies to the order certified to the Court of Appeals, and it is not tied to the particular issue formulated by the district court. So this is minutia about like what the movement or the appellant is applying to for appeal versus the question that is being formulated in front of the district court. It's quite like technical and difficult to understand, but the DOJ really does a fairly masterful job to make it fairly understandable. The third independent basis for appellate jurisdiction is that the special master directive is itself a collateral order, at least as applied to records bearing classification markings. As I've explained this before, an interlocutory ruling is immediately appealable as a collateral order if it is conclusive, resolves important questions separate from the merits, and is effectively unreviewable on appeal from the final judgment in the underlying action. So, and then it explains how. The district court's order compelling the disclosure of documents bearing classification markings in the special master proceedings during the pendency of an ongoing investigation satisfies those criteria. It conclusively determines the government's obligation to disclose those sensitive materials. Compelled disclosure outside the executive branch is an important issue separate from the merits of the underlying dispute, and disclosure once made is irreversible. The relevant inquiry is whether the disclosure of classified records, not the appointment of the special master more broadly, is important and separate from the merits. Likewise, that the special master order is reviewable on appeal is non-responsive to the point that appellate review of a ruling compelling the disclosure of classified documents will likely be futile once disclosure has occurred. Even disclosure only to the special master would be important and effectively unreviewable on appeal, especially in light of the long-standing compelling interest in protecting the secrecy of information important to our national security. As this court, the Supreme Court, has emphasized, courts should be cautious before insisting upon examination of records whose disclosure would jeopardize national security even by the judge alone in chambers, meaning in their office. Even if all three of independent grounds for appellate jurisdiction set forth above might ultimately be found unavailing, applicants still would not be entitled to partial vacatur of the stay because the Court of Appeals did not clearly and demonstrably err in determining that it had jurisdiction. The Court of Appeals held that the government was likely to succeed on the merits because the district court abused its discretion in entertaining applicants' motion in the first place, especially with respect to records bearing classification markings. Oh, please. Applicant does not directly challenge that holding or address Court of Appeals analysis, including its conclusion that he has not alleged, much less shown, a violation of his constitutional rights. Applicant instead contends that appointment of a special master was warranted because this case supposedly involves a document storage dispute governed by the PRA requiring oversight, and because appellant had the statutory authority to declassify records during his tenure in office. Those contentions are wrong and irrelevant. And here's why. The applicant's reliance on the PRA is misguided because he did not comply with his PRA obligation to deposit the records at issue with NARA in the first place, as I said before. As a result, the archivist does not have the custody of those records, and PRA's procedures do not apply to them. Even were that not so, any dispute over access to presidential records under the PRA must be resolved in the District of Columbia, not the Southern District of Florida. If applicant truly believes that this suit is governed by the PRA, he has filed it in the wrong court, which would be yet another reason the government is likely to succeed on the merits. So these are all alternate arguments. It's alternate argument after alternate argument after alternate argument that now Donald Trump has to reply to or answer as dictated by Clarence Thomas's dates, the deadlines for the reply and then what Justice Thomas does with it. Okay. So the DOJ has here provided Clarence Thomas with so many arguments. Each of them on its own would be enough for this appeal to be granted, to be heard, and if the Supreme Court wants to save the judiciary, for them to say enough with this. Or maybe they'll defer to the Court of Appeals for the appeal to happen and then just deny cert when inevitably Donald appeals the full ruling of the 11th Circuit. Because, I mean, Donald will not win this case. This is not a winning case. This is a delaying and obstructing case. And he has now held the judiciary hostage and used the Article 3 branch of our government to obstruct a criminal investigation into him. I don't know if even the most outlandish fiction writer, law expert can come up with this hypothetical. It's just mind-blowing. As for applicants' former authority to declassify documents, despite asserting that classification status is at the core of the dispute in this case, applicant has never represented in any of his multiple legal filings in multiple courts that he in fact declassified any documents, much less supported such a representation with competent evidence. I discussed this earlier. Indeed, the Court of Appeals observed that before the special master, Donald Trump resisted providing any evidence that he had declassified any of these documents, and that the record contains no evidence that any of these records were declassified. So there's no proof that Donald has shown, as I've said before. And in any event, any such declassification would be irrelevant to the special master's review for claims of privilege and for return of property. As the government has explained, the classification markings establish on the face of the documents that they are not applicants' personal property, and the documents likewise cannot contain information subject to personal attorney-client privilege, since they are necessarily government records. That's per executive order something 13,526. 7th footnote. In the district court, applicants suggested that some of the seized records might be subject to executive privilege. But applicant all but abandoned that argument in the Court of Appeals, and the application does not even mention it. With good reason. Applicant has identified no authority for the suggestion that he could invoke executive privilege to prevent review of executive branch records by the very executive branch in whose name the privilege is invoked. Nixon versus GSA, Administrator of General Services. And in any event, any such invocation would necessarily yield to the government's demonstrated specific need for evidence in its criminal investigation concerning the wrongful retention of those very documents and obstruction of its efforts to recover them. That's United States versus Nixon. Thus, the Court of Appeals emphasized applicants' declassification argument is a red herring because declassifying any official document would not change its content or render it personal. Okay. This court has expressly left open the question. So now we move on back, so to speak, to the jurisdiction. This is now the DOJ's getting to its jurisdictional assertion. This court has expressly left open the question of whether an order compelling disclosure of classified government documents is immediately appealable as a collateral order. And Donald, in his filing to Clarence Thomas, says that it is clearly wrong that the 11th Circuit has asserted jurisdiction on this order, this collateral order. This court has not had the opportunity to apply the logic of Yamaha and BP to the parallel language in section 1292A or to address pendant jurisdiction in circumstances like these, the exercise of appellate jurisdiction here cannot be said to be clearly wrong. So, because of the fact that this is effectively a case of first impression, there's no authority from the Supreme Court or anywhere that talks about the 11th Circuit's assertion of jurisdiction in this case on the basis of collateral order would be clearly wrong. Finally, the appellant does not contend that the Court of Appeals clearly and demonstrably erred in applying any of the other equitable factors constituting the accepted standards for a stay pending appeal. Those factors include whether the government would have been irreparably injured absent a stay, whether issuance of the stay would substantially injure those parties, and where the public interest lay. The court applied that standard and found that all of the factors favored a partial stay. As relevant here, the Court of Appeals explained that the government would be irreparably injured by having to disclose the classified records, some of which reflect the highest levels of classification and extraordinarily restricted distribution, to the special master, the applicant, and the applicant's counsel, in light of the long recognized compelling interest in protecting the secrecy of information important to our national security. The court found the public interest favored a stay for largely the same reasons. The court also observed that the applicant had not explained how he would be harmed by the limited scope of the stay with respect to the documents bearing classification markings. None of those findings were clearly wrong, and applicant does not contend otherwise. So, this is the DOJ again pointing out that, Donald has offered no good faith argument at any point, including here, when it comes to the exercise of the appellate court's jurisdiction. Indeed, applicant devotes only 2 conclusory statements to irreparable injury. He asserts that it is unnecessary for him to make a showing of irreparable injury because the government is not likely to succeed on appeal, and that irreparable injury could most certainly occur if the government were permitted to improperly use the documents seized. The first assertion cannot be reconciled with the very standard applicant cites, which requires a showing of irreparable injury in addition to a likelihood of success on the merits. Indeed, vacating a Court of Appeals stay absent a showing of an irreparable injury would be inconsistent with both the great deference owed to the lower court's decision and general principles governing the granting of extraordinary equitable relief. Applicant's second assertion that he could be irreparably injured if the government improperly uses the documents is irrelevant because his application disclaims any request for vacatur of the portions of the Court of Appeals stay concerning the government's use of the seized documents bearing the classification markings. Instead, Donald seeks vacatur only to the extent that the stay precludes the special master from reviewing the classified documents. Applicant has not asserted, much less demonstrated, any irreparable injury that would result from that portion of the court's stay. So he hasn't shown the injury that would happen for the relief he's asking. He's asking relief for in the sense of returning the documents to Judge Deary and his lawyer, but he's not showing why not returning that would cause him irreparable injury. But he's claiming that he could have irreparable injury if the government uses it improperly, without having shown in any way that that has happened or will happen. Indeed, because applicant has no plausible claims of ownership over or privilege in documents bearing classification markings, he will suffer no harm at all from a temporary stay of the special master's review of those materials while the government's appeal proceeds. An applicant further undermine any claim that he's suffering irreparable injury from the stay by opposing the government's motion to expedite the underlying appeal and urging that oral arguments be deferred until January 2023 or later. So Donald's own argument of delaying the full appeal works against him if he's trying to say that he is suffering irreparable injury, because that would mean that Donald would want the judicial process, the review to be expedited, not to be delayed. DOJ has just eviscerated Donald. Applicant's failure to establish any risk of irreparable injury provides yet another independently sufficient reason to deny his request to disturb the modest partial stay entered by the Court of Appeals. And it is a modest stay for those 100 or so classified documents. And I don't see how Clarence Thomas would even refer this to the full court. If he does anything unilaterally, that would just be just I don't know, extrajudicial on its face, wrong, violation of moral or ethics. But then again, there is no ethic code that governs the Supreme Court. I don't know if there are any rules that can stop him from it. But this is an abuse of discretion. This is a disrespecting the courts. This is just wrong on many levels. And the Supreme Court can and should shut it down. Thank you, Zoila. So that's all I have today. And if you have any questions about it, do comment, subscribe, like, unlike, whatever you think. And now we wait for Donald's response to this reply, which, I don't know how his lawyers are going to reply to this, but looking forward to it. Not really. I mean, I don't know what they're going to do. But let's see what happens. Mind you, the proceedings of the 11th Circuit is going to be, I think, November 17th, as mentioned in this reply. So let's wait and see what happens there. And thank you for everybody who has been here. Let's see. And take care. Thank you.